Hello friends, before starting today's main topic on the Indian Contract Act 1872, where we'll discuss meaning and definition of a contract and the essentials of a valid contract, let's understand the concept of law as well as the concept of business law, because contract is a part of business law and at the same time business law is a part of a broader term law. Now the question comes, what is law? Law means a set of rules which regulate our relations with other individuals and with the state in a civilized society. Law is almost a universal need. No society can exist without a legal order. Without law, there would be a complete anarchy in society. That's why we regard rule of law as the essence of a civilized society. Now let's understand the term business law. Law and business are closely related disciplines. They complement each other. Law is a major factor in business decision making. Almost every aspect of business is regulated by law. Sometimes the law may require business to provide certain facilities to its employees even when the contract does not provide them for. For example, labor law for Provident Fund, PF, ESI, that is employee state insurance, etc. Law is the foundation for the regulation for all business conduct and decisions. Further, law provides a mechanism by which disputes between different parties are settled. Thus, there may be a dispute between business enterprise, on the other hand, an employee, customer, government, dealer, creditor, etc. For example, if shopkeeper sells a defective product to a customer, he has a number of remedies under different legal provisions. That's why business law is required to understand. Now the question arises, why should one know law? There is a Latin maxim related to this question, that is Ignorantia, juris non excusat. That means ignorance of the law does not excuse, or ignorance of law is no excuse, which means there is a legal principle holding that a person who is unaware of a law may not escape liability for violating that law merely because he or she was unaware of its content. Suppose you violate any rule, suppose you are driving on a road and you don't know this is wrong side or right side, and you violated the traffic rule, you cannot escape that you are unaware of this law. So, ignorantia juris non excusat. Everyone should know the law. It is a common presumption. The adjudication of the law is generally divided into two main areas. Number one is criminal law and the civil law. Here we are studying contract law, that is a branch of civil law. Let's understand what is a contract. Section 2 subsection H of Indian Contract Act 1872 define the term contract. An agreement enforceable by law is a contract. This is very simple one-line definition, which says contract is equal to agreement plus enforceability at law. The basic two ingredients which constitute contract are number one, agreement, and its enforceability. In this slide, we'll understand various stages of a contract. First one is proposal or offer, then promise. Next stage is consideration, and then agreement. Agreement may be a valid and void. There are two types of agreement, but here we'll discuss valid. And last one is contract. Contract is voidable, void, and a valid contract. Now it's very important to understand these two terms, promisor and promisee, or simply we can say offeror and offeree. These two terms are very common, very frequently used in this topic, so let's understand. The person making the offer is known as the offeror, proposer, or promisor. And who is the offeree? The person to whom it is made is called the offeree or proposee. And what is the promisee or promise? When the offeree accepts the offer, he is called the acceptor or promisee, which is given in section 2, subsection C. With the help of this slide, we'll try to understand the contract in detail. This circle shows the agreement, and this circle depicts legal obligation, and this bifurcation shows the contract. Only this person is a contract. Thus simply we can say all contracts are agreements, but all agreements are not contracts. So contract is equal to agreement and enforceability before law. Enforceability before law is very important in a contract. Otherwise, it's simply an agreement, not a contract. Now, let's understand the other important topic is essentials of a valid contract. Under essentials of a valid contract, first point is two parties. Otherwise, if two parties not available there, then it's not a valid contract. In simple words, we can say one cannot contract with himself. A contract involves at least two parties. One party making the offer and the other party accepting it. A contract may be made by natural persons and by other persons having legal existence. Legal existence means a company, a university, an NGO, etc. For example, in a contract of sale, there are always two parties, a seller and a buyer. The second important point of essentials of a valid contract is intention to create legal relationship. In case of social agreement, there is no intention to create legal relationship and there is no contract. Balfour versus Balfour is a landmark case related to intention to create legal relationship. In case of commercial agreements, the law presumes that the parties had the intention to create legal relations. An agreement of a purely domestic or social nature is not a contract. Let's understand this with the example of a case. Suppose A and B agree to go to a movie on coming Sunday. A does not turn in, resulting in loss of B's time and money. B cannot claim any damages from A, since the agreement to watch a movie is a domestic agreement, social agreement, which does not result in a contract. The third point is lawful object and lawful consideration, which means two persons cannot enter into an agreement to do a criminal act or any act which is unlawful. Consideration or object of an agreement is unlawful if it is forbidden by law or is of such nature that, if permitted, would defeat the provisions of any law, or is fraudulent, or involves or implies injury to person or property of another, or last one is court regards it as immoral or opposed to public policy. It is important point, object must be lawful, object of contract, and the consideration. Consideration means something in return. That also must not be unlawful. Fourth point is capacity to contract. The parties to a contract must have capacity. Capacity means legal ability to make a valid contract. Section 11 of Indian Contract Act 1872 specifies that every person is competent to contract, provided number one is of the age of majority according to the law which is subject, and who is of sound mind, who is not disqualified from contracting by any law to which he is subject, and an alien enemy, foreign sovereigns, and accredited representative of a foreign state, insolvents, and convicts are not competent to contract. Means, let's understand again first point, that is, minor cannot enter a contract. Only major above age of 18 can have capacity to enter a contract. Number one, person must be of sound mind. A person of unsound mind cannot enter a contract. Next point is person disqualified from any law is not capable to contract. An alien enemy, foreign sovereigns, a convict, insolvent, these people are also not competent to contract. Next point is free and genuine consent, that is free from these 5 points. Number one is coercion, next point is undue influence, third point is fraud, fourth is misrepresentation and mistake. Coercion means threatening. If any person threaten with the help of gunpoint and got a consent, that is not a free consent. Undue influence from any spiritual guru or lawyer, doctor, they get undue influence and influence the other party, get consent, that is not a free and genuine consent. Fraudulent activity involved in any contract is also not a genuine consent. Next one is misrepresentation. Facts are not given in right manner, that is misrepresentation, representing the wrong facts, that is misrepresentation. And mistake, by mistake if anything happened between the two parties, that is not a free and genuine consent. So a valid contract must have free and genuine consent. Next point is consensus ad idem. Consensus ad idem means meeting of minds. That is, person must agree to the same thing in the same sense and at the same time. Suppose buyer and seller, whatever buyer wants to say, the seller must exactly understand the same thing. Suppose buyer wants to sell a particular car at the fixed price. The buyer understands the other car which is more expensive at the lower price. So that is not consensus added on both persons not understanding the same thing in the same sense. Right? Next point is possibility of performance. Impossible things which cannot be performed is not a part of essentials of a valid contract. The terms of the agreement should be capable of performance. An agreement to do act impossible itself cannot be enforced. For example, A agrees to B to discover treasure by magic. The agreement is void because the act in itself is impossible to be performed from the very beginning. The next point is certainty of meaning. The terms of the agreement are certain or are capable of being made certain. Simply we can say certainty of meaning. Meaning must be certain. We'll take here two examples. Number one, sale and purchase of 100 liters of oil. An agreement has been made, but which oil? Thus, agreement being uncertain is not a valid contract. But the seller deals only in one kind of oil and one variety, then it shall be valid, since the seller is selling only one kind of oil, so it is understood and meaning is certain. So it's a valid contract. Next example, A agreed to pay rupees 5 lakh to B for ultra modern decoration of his drawing room. The agreement is void because the meaning of the term ultra modern is not certain. Thus we can simply say certainty of meaning is an essential part of a valid contract. Here, the ninth point is agreement not declared void. The agreement should be such that it should be capable of being enforced by law. Certain agreements have been expressly declared illegal or void by the law. If agreements are declared illegal and void, then that agreement must not be a valid contract. The 10th and the last point of essentials of a valid contract is necessary legal formalities. First point is a contract may be oral or in writing, but in most of the cases, writing agreements are most necessary part of a valid contract. Otherwise, you cannot prove, you cannot claim that the agreement has been made valid. Next point, where a particular type of contract is required by law to be in writing and registered, it must comply with necessary formalities as to writing, registration and attestation. If legal formalities are not carried out, then the contract is not enforceable by law. For example, A promised to pay a time-barred debt must be in writing. There are certain legal formalities. Suppose you got a property transfer, or selling or purchasing printed invoice, which kind of legal formality. Legal stamp papers are the legal formalities without you can't claim. So necessary legal formalities are the essentials of a valid contract. You understand now the concept of contract, the definition, meaning, and the essentials of a valid contract. If you like this video, please subscribe, like and comment, and in the next video I can assure you the other important things will be shared very soon. Thank you so much for watching.